So a federal court in Texas has expanded a preliminary injunction to block the ATF's new rule on frames and receivers. So let's talk about this. Also want to thank one of the new sponsors of this channel, which is Blackout Coffee. Blackout Coffee is a family-owned and operated company here within the US. Blackout Coffee is a huge supporter of the Second Amendment and the Second Amendment cause, and that's why I chose to partner with them and actually have them as a sponsor to this channel. So if you want to support an American company that supports the Second Amendment, I highly recommend you check out Blackout Coffee. You can check them out by going to blackoutcoffee.com/armedscholar. I will also leave a link to them down in the details section in the comment section. And if you use the code ARMEDSCHOLAR, you can get 10% off of your order. As I mentioned in the intro, in this video, we'll be discussing how the ATF has suffered another significant loss in the Texas federal case challenging their new rule on frames and receivers. The case we will be talking about in this video is called Vanderstock v. Garland. This is a lawsuit filed in the Northern District of Texas against the ATF and their new rule on frames and receivers, which went into effect in mid-August. In this case, a federal court judge just granted Defense Distributed, a manufacturer and seller of 80%ers, a preliminary injunction. Therefore, the preliminary injunction protects the company and their customers until this case is fully resolved at trial. As you may recall, in this case, Vanderstock, plaintiffs sued the ATF and are seeking for a federal court to find that this new rule is in fact invalid under the Second Amendment. In the lawsuit, the original plaintiffs also requested a preliminary injunction from the court to enjoin, i.e. halt the enforcement of the ATF new rule while this case is making its way through the process. On review, a federal court judge, Reed O'Connor, granted a limited preliminary injunction against the ATF. Looking at the ATF's rule on frames and receivers, he found that it was facially invalid under the plain text of the statute and that Congress did not grant the ATF authority to regulate these types of items. So he granted a limited preliminary injunction in favor of one of the plaintiffs, which was originally Tactical Machining. Later, he expanded the injunction to protect the individual named plaintiffs in the case and also the customers of that one company, Tactical Machining. After that, multiple 80% companies sought to join this case as plaintiffs. 80% Arms and also Defense Distributed were the most recent ones who were allowed to join this case as plaintiffs. Also, Second Amendment Foundation, or SAF, a 2A organization, also joined this case as a plaintiff. Then after being added into the case as a named plaintiff, SAF and Defense Distributed sought for Judge O'Connor to grant them a preliminary injunction similar to the one that was already granted to Tactical Machining and also 80% Arms. They also sought for a preliminary injunction to be granted to protect SAF and its individual members. This request became even more important since recently the ATF published an open letter stating that even items sold on their own would fall under the ATF's new rule on frames and receivers. This, of course, was contrary to what the ATF had told us prior, because prior the ATF had claimed that under this rule only parts kits or complete kits or items sold in conjunction with instructions, jigs, or tools would in fact impacted. But recently in the ATF's open letter, they in fact stated, applying the regulatory text of the final rule 2021-05F, partially complete polymer 80, Lone Wolf, and similar striker-fired semi-automatic pistol frames, including but not limited to those sold within parts kits, have reached a stage of manufacture where they may readily be completed, assembled, restored, or otherwise converted to a functional frame. This definition of readily applies to each and every classification of a partially complete frame receiver under this rule, whether sold alone or as part of a kit. Therefore, they stated, even without any associated templates, jigs, molds, equipment, tools, instructions, guides, or marketing materials, these partially complete pistol frames are frames and also firearms as defined in the GCA and its implementing regulations. So in response to all this, SAF and Defense Distributed sought a preliminary injunction to protect them and their customers against the ATF. Well, recently Judge Reed O'Connor has once again struck down the ATF's frames and receivers rule by granting an expansion of that injunction in favor of Defense Distributed. However, I do also want to note that he did not grant SAF as an organization the same type of relief. Personally, that wasn't a big surprise since Judge O'Connor had prior denied FPC as an organization their request for protection and protection for their customers or their members. So he had already denied an org the request prior, so it wasn't surprised that SAF was also denied the same type of relief. but he did grant the relief requested by Defense Distributed. In granting the preliminary injunction, he stated, Defense Distributed has shown that it is likely to suffer irreparable harm through unrecoverable lost revenues and potentially eventual total dissolution of its business if the court does not provide injunctive relief while litigation is ongoing. Solely in response to the final rule, Defense Distributed avers it ceased dealing in unfinished frames, unfinished receivers, and frame and receiver parts kits out of fear of violating the new regulation. That this fear was well-founded was later confirmed by the ATF's open letter, identifying certain types of partially manufactured frames, receivers, and parts kits as firearms for the purposes of the GCA. Though the government contends that Defense Distributed's description of its products is too vague to justify a finding of irreparable harm, this court disagrees. At least one of the products Defense Distributed sold previously, then stopped selling following the final rule's enactment, the Polymer 80 pistol frame, is now considered a firearm under the new regulations. In response to the final rule being released and published, the company here completely stopped selling these items, and its customers have actually stopped purchasing these items from the company because they fear that the ATF will in fact enforce the rule against them. Therefore, the judge found a preliminary injunction should be granted to protect this company, Defense Distributed, and its customers as well from the ATF and their final rule on frames and receivers. However, the court did not grant protection to SAF as an organization and its members as well because of a very technical distinction. He stated, though the court previously held that a threat of criminal prosecution that has a chilling effect on a consumer's choice to engage in previously lawful activity can constitute irreparable harm, no such harm exists here. Indeed, SAF's members may lawfully purchase such articles from firms like Defense Distributed, namely Tactical Machining and Blackhawk Manufacturing Group, under the current injunctions. And SAF has not shown how its members' ability to purchase unfinished frames and receivers and parts kits from Tactical and Blackhawk, but not from Defense Distributed or other firms, constitutes an irreparable harm that can only be alleviated with an injunction. He goes on to also state that, moreover, should Defense Distributed be entitled to injunctive relief, and then he says it is, SAF's members' purported injury is further alleviated. So there, Judge O'Connor is stating that the SAF's claimed injury is in fact resolved by its members being able to purchase these types of similar items from other companies like Tactical Machining and Blackhawk Manufacturing Group, who have already been granted an injunction by the court here and by Judge Reed O'Connor. He also states the fact that he is granting a preliminary injunction in favor of Defense Distributed in this very order will further cure any claimed injury to SAF and its members. Therefore, he did not grant a preliminary injunction to SAF and its members as an organization. So that is the recent news in the challenge to block the ATF's new frames and receivers rule. SAF, on behalf of Defense Distributed, was able to get the preliminary injunction expanded by the court to block the ATF from enforcing this new frames and receivers rule against this one company of Defense Distributed and also its customers as well. I think this whole frames and receivers issue and all these challenges are heading in the right direction. I think ultimately this case is going to be resolved in a very favorable way, and I think it's also going to set the framework for other challenges to other ATF rules, like the challenges to the ATF new pistol brace rule. So if we get any more information, I will let you all know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.